Hello, I'm Dane Frew and welcome to another episode of Divorce Unplugged. As always, I'm joined by Geoff Abbott. Geoff, how are you? How's things in your world?
My world's really good, Dane. Thanks. Yeah, we're been keeping busy, keeping people moving forward in their family law matters, and generally I've been trying to keep my exercise regime up and looking after myself.
Good to hear. So today we're going to take a deep dive into the actual process of getting divorced. We've called it Getting Divorced, the process from A to D. So let's kick it off, shall we?
Let's dive in.
All right, so let's start with an obvious one. Who can get divorced?
All right. Well, the simple answer is somebody who is married. So if you're in a de facto relationship, you don't need any formal document to get to prove separation or to remarry. But if you are married, then you do. And of course, someone who is married needs to be separated for 12 months to file for a legal ending of the marriage or a divorce.
So why would someone want to get a divorce?
Well, I touched on the first one. Do they want to get remarried? Is an important topic. Some people simply want to end the legal binding nature of the relationship. So upon a separation, it's important to them to, I suppose, start with a clean sheet and formally end the union.
Just start afresh, get the weight off the shoulders, like a spring clean.
Exactly that. And there's one other reason, which is to do with property settlement. Sometimes people will file for the divorce because it creates a time limit to then, in the division of their assets, 12 months after that passes, essentially what you've kept and what your spouse has kept is the final agreement without the permission of the court to reopen it, basically.
So you touched on before about separation. So what defines a separation?
Well, a separation it's a question of fact. So I've said that previously, that there's no formal decree of separation. If I tell my spouse that we're separated, and in my mind I'm separated, we are separated. Conversely, if my wife tells me that, then that's what it is. Usually, when I talk about a question of fact, I talked about, well, what are the real examples of what constitutes a separation? Is it moving into a separate room? Is it telling people? Is it advising a government body like Centrelink that you've separated?
So do you have to formally announce a separation or do any paperwork?
No, there isn't any formal separation declaration as such.
That could prove, I guess, when it comes to that divorce time, that could bring upon a few challenges. I guess if it's my word v someone else's word,
it does.
Something like that.
It does, because I have touched on occasionally the fact that if you do separate and want to file for a divorce, sometimes a dispute over the date of separation is one of the biggest issues that gets in the way of the divorce order being made.
All right, so you're eligible to apply for a divorce. Are there any preliminary things that you should do?
Yes, get a couple of things sorted out. One is importantly your paperwork. So you've got to have your marriage certificate. If it's in another language, you've got to get a translation of your marriage certificate. Do I have my citizenship paper if I've become an Australian citizen? That's important as well. Sometimes if you're living in Australia and you want to apply for a divorce and you're living here under a residency arrangement, you're not an Australian citizen, we would organise your residency paperwork, and it's called a VEVO, V-E-V-O application, which you can go online and which basically shows that you've got a right to live here.
So once you've got your initial paperwork organised, what happens then on a practical level?
On a practical level, you put together the divorce application form itself. It used to be sent off back in the day, which is not that far long ago, in triplicate to a courthouse registry, or someone would walk it into the registry and the court would look at it and see if it's basically completed correctly, and they would keep a copy and put some big stamps on the others, one for you and one to send to the other spouse, and off you'd go. But over the last few years, we've developed, there's a portal that the federal government has called the Commonwealth Portal, which allows you to file your divorce application and all the supporting documents electronically.
So you've just touched on them where it's filed. So who prepares the divorce application?
Well, it's an applicant. So when I say an applicant, you've got two choices when you file for a divorce. You can file for it jointly, where both the husband and wife are an applicant, or either party, if they wish to apply for divorce after 12 months of separation, can file as the applicant. Now, that can be done personally. You can do it if you want to register on the Commonwealth Portal and complete all the paperwork, or you can engage a third party such as a solicitor to assist you in doing that.
So is the application signed before being filed?
Yes, so there's one form, it's called an e-file by technical name, but basically it's a declaration that sets out that what you've said in your divorce application is true and correct, and that you're wanting to proceed with the divorce. So that's signed, and it's actually then witnessed. You have to have a witness, and that varies around Australia. But a JP and solicitor, for example, are common witnesses that we see.
So is there a cost to that, to file the paperwork?
Yes. As of 1st of July 2024, the government, in its wisdom, has increased the divorce filing fees again slightly. So it costs $1,060 to file a divorce application, or you get a discount down to $365 from 1st of July if you have a healthcare concession pensioner card, or you can demonstrate absolute financial hardship, for example.
Okay. Is there any other way to obtain a discount?
Well, I just touched on the financial hardship. So there is a form that you can file if you don't have one of those cards. For example, if you've just lost your job 6 weeks before and you're living with very little money in the bank, you can file an application to say, look, I don't have a concession card, but I also financially am not in a position to pay the full $1,060 or $1,100 from the 1st of July. And the court, the funny thing is you don't know if the court's going to accept that when you file your application until after they've had a look at it. So there's no preliminary way of checking.
So you don't know.
No.
Okay. So when does the applicant get a hearing date?
So the applicant is issued with a hearing date on when they file the application. So if it's processed and essentially stamped by the court, they will give you a hearing date. And that, depending where you file it around Australia, there are multiple, there's not one central court. So for example, if you live in Brisbane, you file it in the Brisbane Registry, which is the closest one. It's still a bit of an anachronism because it's all done electronically. But if you file it, basically you may get different hearing dates depending on how busy each of the courts are, or some regional courts, without me going into too much detail. If you file, for example, in Cairns, they may have once a month, they will have their 15 or 20 divorce hearings.
Yep. So how long down the track is that?
Usually there are two ways to look at it. For an application which is filed by an individual, you probably need to allow at least 8 weeks from the time of filing, for the reason that you've got to serve the application, and 28 days will have to pass before the hearing then occurs. Or in a joint application, because you don't have to worry about service, you can probably sneak it in a bit quicker. So you might be able to get it in even 4 to 6 weeks after you've filed it.
Yeah, right. So what happens with the application once you've received the filed copy and you've got your hearing date?
All right, so here we are. We've now downloaded the filed copy off the Commonwealth Court portal. We have to arrange, in the case of a individual application, you've then got to be able to serve it or give it to the other party in some way.
So is there a difference between a joint application and an individual application?
There is. So in a joint application, once the hearing date is set, then usually there's not a requirement to either serve it or file other paperwork about service or other issues, unless there's some significant change in circumstances. For example, there was a major change in the care arrangements for the children. It might be appropriate to file an affidavit advising the court of the change. So a joint application, although we only do about 1 in 5 of them as a joint, is a little bit simpler.
So I guess service of divorce application can be a topic on its own, and you've shared a few stories about that in an earlier episode. But once we get to the point that service has actually occurred, is there any more paperwork that then needs to get to the court?
There is. So we have, because there's a couple of different ways service occurs, I'd lump it all into that you have to then file paperwork that shows how service occurred. For example, if a process server handed your former spouse a copy of the divorce application, that process server has to swear an affidavit showing that they did that. Funnily enough, if the spouse signs a form called an acknowledgement saying that they received it, then the applicant spouse has to actually file an affidavit saying that they recognise the signature. Oddly enough, if they refuse to sign it, you don't have to. Doesn't make a lot of sense to me,
No.
but that's what the rules state. If you've posted it to the other party and they send it back to you with their signature, again, you've got to sign a form saying that's their actual signature. So, and again, if we get more complex service, which I've talked about, like for example, if we've had to serve by email or some other electronic means, we then would normally have to swear an affidavit about how we went through that process.
Right. So take us inside the courtroom. Are you able to explain what happens in a court hearing for a divorce?
Yes, absolutely. Happy to do that. Once upon a time, and this is only 2020, coming to 2021, the majority of divorce hearings were actually done in person. In other words, the applicant and the applicant's solicitor, if they've got one, would queue up with about a dozen other people at a set time at a registry, say in Brisbane at 9:30 on a Tuesday, and one by one they would go in and have their divorce application heard. Now, post-COVID, the court has changed that all to an electronic system, so that even though we may still have 12 or 15 matters on, we actually then do them electronically. So we all ring in to the court, and we're all put ourselves on mute, and one by one the court will call out the matters, and then we'll determine whether the divorce application will proceed.
So will the party who applied for the divorce, do they need to attend that, whether it's online or in person?
Generally not, if they're represented by, for example, ourselves or a solicitor. Yep. So you might want to attend to actually hear the divorce order being pronounced, but it's not compulsory. And similarly for the respondent, sometimes they attend, sometimes they don't.
Okay, so that's up to them with the respondent, that the application being that's on the other spouse, they can choose to attend if they want to as well.
That's absolutely correct. So normally we'll see a respondent potentially attend if they think there's some issue of dispute. So they might have filed a response arguing that the care arrangements for the children aren't in accordance with the application. They might want to come along and tell the registrar that as well. The registrar of the court, if we dig into the process a little bit more, the registrar of the court who listens to these matters, firstly determines if your application is a viable one. So they review the documents to make sure you've got all your documents there, your marriage certificate and your citizenship certificate, and the application shows that you've been separated for more than 12 months and those practical things. And then they'll look at the documents in relation to service of the paperwork to make sure it all is accurate and been properly signed and witnessed, and sometimes we'll have the wrong witness pop up or something like that. And if all the paperwork's in order and there's no dispute, which is called, the respondent, the other spouse hasn't filed something disputing the date of separation or children's arrangements, if the court's happy about the children's arrangements as well, then they'll give it the big tick and they'll pronounce the initial divorce order.
So what's actually spoken about in the courtroom, and who from the court attends?
Well, I've given a little bit of a rundown, but it's the registrar of the court. So the court has, they have judges, and most people are familiar with that term. A judge goes to court, but
they have one of those wigs on their heads.
Usually, yes.
Do they? Yeah,
so
right.
They do. Not always, but some do. But a registrar is basically the most senior court officer below a judge, and there's various levels of them without being boring. But they're allocated the task of determining whether a divorce application is valid or not. So they're the ones who hear it, and they're the ones who, some of them have actually read all of the documents before you start, so they've got a head start, and they'll say, Mr. Evatt, I've read all the material and it all seems to be in order. Do you have anything else you want to say? So those hearings are nice and straightforward. Yeah. Sometimes I say, Mr. Evatt, I've read the material and there's some deficiency. And I'll go, that's very unusual. But then they might ask about something. They might say, look, I'm not entirely satisfied that I'm not sure what, year the children are in or what's happening with the care arrangements for the children currently. It seems a bit unsettled, and we might have to give them a bit more information. And sometimes matters are adjourned. Not every matter goes through on the first occasion.
So two parts quickly. So I guess the time and the length of the hearing can depend on if the registrar is happy with the information that's in front of them. So two parts of this question. I guess, on average, how long does a hearing take, and then what happens if something does go wrong, like you just said, there's an adjournment? Why? Can you give us an example of why a matter may be adjourned, and then how long is an adjournment?
Yes. All right. Let's talk about
Get to that.
Yep. So a divorce hearing varies in length, so it could be as short as 3 minutes, to be honest. If they've read the material and it's a very straightforward application, a divorce hearing will be quite short.
So it could be tick, 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 done, next one.
Yep, that's it. So that's why they can do 10 or 12 matters in just over an hour.
But if something's to go wrong...
Then it could take 10 minutes. And I find, unfortunately, a lot of people do file their own divorce applications. And if they haven't got their paperwork right, they struggle sometimes to understand what the registrar might be asking them. There might be some language barriers as well.
Yeah.
So some of those matters could drag out for 10 or 15 minutes before we get a resolution, or the matter might need to be adjourned and the registrar has to explain what's needed to get the matter moving forward.
So an adjournment would only happen if the registrar is not happy or can't get the answers within that period of time.
Correct.
Is that right? And then how long is an adjournment?
Well, there's two types of adjournments I would probably describe. One is a short adjournment, for example, if you've served the divorce paperwork, but it's only been signed off by the respondent only, say, 20 days before the hearing rather than 28 days. They might give a short adjournment of only a couple of weeks to allow that full 28 days to go through before bringing it back on and dealing with that divorce application. Most other adjournments tend to be for sort of around 4 to 6 weeks, and there's two reasons for that. One is that the court availability itself, so the court doesn't have any of the slots, I'll call them, available until 4 to 6 weeks down the track. And the other one is it allows enough time to fix whatever the problem might be. And for example, if there's a dispute over the separation date, the court might send the matter away and let the parties try and have some discussions about whether they're in fact going to contest having it over whether the date is in dispute, or the court might need more information about service, or the court in fact sometimes is asked by us to allow service in another way. So if I need to get an order to serve it by WhatsApp or by SMS, because that's the only way I've shown to the court I can communicate with the responding spouse, the court will say, look, I'm going to send the matter away for 6 weeks. You send the documents off by that method, and then you give me an affidavit that shows that you've done all of that. And then when we come back in 6 weeks' time, if everything else is in order and the respondent hasn't suddenly decided to contest it for some reason, then I'll make the application final hearing then, or the divorce order.
Yeah. So what does the court do at the end of a hearing?
So it says has a standard summary. It says it makes a series of findings. So it says I find that the parties were married, and I find that the marriage is broken down irretrievably, and I make a finding that there is sufficient care arrangements for the children, and in all of the circumstances make a divorce order at that time. It's called a decree. In Latin, there's two phrases. It's called a decree nisi for the technically minded. So that's the initial decree of divorce.
Okay, so is that the end of the divorce then?
Not quite.
Right.
So
what then happens?
Well, you've got a final decree has to be made. So that's all done on the papers. So what does that mean? So in plain English again, a month and a day after the hearing of itself, a final divorce order is made. So if you have a hearing on the 15th of May, on the 16th of June, that gap of a month and a day has to occur. The final order of divorce is made, and the actual final divorce order, or divorce certificate, some people will call it, is then issued by the court.
So does the final divorce order or the certificate then get sent to the applicant?
Yes, it's available these days. In the old days, you'd be sent a nice copy from the court back in the paperwork days. But because it's all electronic now, we download the copy and then we'll give it to the applicant, our client. So the applicant gets a copy, and if it's a joint one, both parties will automatically get a copy from at that point.
But what about the other party if it's not a joint application?
No, well, they to get a copy, they sometimes will ask us, and we'll, as a courtesy, generally give it to them. But otherwise, they would have to go onto the Commonwealth portal and register as a party to the hearing, and then be able to download it themselves. So they've got to go through a bureaucratic process to get their own copy.
Yep. So what can an applicant do once they receive that final divorce order?
Well, there's a couple of things that come to mind. The first one is, of course, they're entitled to remarry. But a lot of people use it as a catalyst for changing things like the change of name. So if you were married and became Mrs. Smith, you might want to return back to Ms. Jones again and go back to your maiden name. Some people will jump back if they've had more than one marriage, back 2 names, for example, if they want to. After the final order has gone through, because you can then use that document to show to government registries like the Department of Transport, like for your driver's licence, or those sort of things, to then use that as good evidence to show that why I'm unable to legally change my name on more formal documents.
All right, well, that gives us that's a wrap, I guess, of divorce from A to D, and you've covered it from the start all the way to the end, which was really insightful. So now we move on to our health topic.
Could I just mention one thing before we do? Because people might have wondered, well, hang on, why do they wait a month and a day between the first divorce hearing and actually issuing the certificate? And the theory is this. They wanted to allow a final opportunity for the parties to potentially reconcile. So we have had the situation on occasion, not very often, but on occasion, where the parties have said, oh, even though the first divorce order was made and I've been told that we're getting divorced, that we want to give it one more shot. And if you do, you've got basically that month to make that decision. And if that happens, then there's actually a form or another document you lodge with the court saying, hey, we withdraw the application and the divorce order is never finalised.
Right. Interesting. Okay. Anyway, your health topic.
Yes.
Your health topic. You wanted to speak about mental health and around divorce and separation.
I did.
Yeah.
I think one of the things that, is part of the whole big picture is trying to getting people moving forward is obviously their mental health. We've talked about their physical health and other things on other episodes, but perhaps we can focus a little bit on that today.
Yeah, so what area exactly did you want to talk about?
Well, I wanted to talk about one of the things that impacts not just people who are separated, but people generally, and that's the issue of negative self-talk. So that voice in your head.
Yes, we all have that. So do you have any useful books or articles or anything that you fall back on when you're looking at self-talk that you might be able to help some people out with?
Yeah, I wanted to throw one up today if I could, and that's an article by a gentleman called Tim Urban that was written in 2014. So we might be lucky enough to throw a link to that in our show notes.
Yes, we'll do that.
Thank you, Dane, for doing that. But it's an article called Taming the Mammoth, and it goes into the issue of that voice in your head.
Yeah, so can you tell us a bit about the article?
Sure. So it's actually written almost in a comic book version because it has images as well, and it uses the mammoth, or an image of a mammoth, the old woolly mammoth, in fact, as that voice in your head, and uses it to sort of step through how negative self-talk actually impacts on you. So he uses the mammoth to talk about that part of our brain that wants to control us and make us feel anxious or insecure because of the need to feel social approval or conform with the tribe. So this is sort of an ancient part of our brain that goes back, and that's why self-talk in that sense occurs.
So what were your key takeaways from that article?
Well, in a humorous and sort of thoughtful way, he points out a couple of things, and he says, look, whilst we used to have to live in tribes, and if you were excluded from a tribe back 5,000 years ago, that probably was instant death because you couldn't live by yourself. He says now, for example, firstly, that you should work out your own values and what's important to you and not others. He talks about, look, if you want to get feedback, then you should get that from people who respect you, not from those people who might want to manifest their own insecurities or jealousy. And he's very much an advocate for pursuing your own passions and interests intently. So finding ways to get out of your comfort zone, but to contribute to the world in a meaningful way.
Good. I'll have to have a read of that myself, and we'll make sure that we copy a link of that into the show notes on our social media platforms as well.
I hope people get a chance to read it. It's not a long article, and it probably anyone from the age of 10 years and older can read it. So you can even potentially show it to your children because I think self-talk starts at a very early age.
Yeah, absolutely, it does. No, well, thanks for that insight and that for touching on that health topic, a very important one, and thanks for taking us through the A to D of divorce in some detail as well. It gives us a bit more of an understanding as to what it takes from start to finish. So I appreciate your time and for that information.
Dane, it's again been a pleasure to have the opportunity to talk to you and again impart a little bit of information as well.
Sounds good. Thank you.
Thanks, Dane.